So thank you all for joining us yet again for the third session of our first day of this virtual workshop on the land back movement. We wanted to, obviously, there's been a lot of questions about this already, but dig into land back and federal Indian law and how current policies impact efforts to restore sovereignty. And so that's
Then
something
you can
that
say
we
something like "you people."
let
You
me
can
see.
give her a "you people" statement.
Oh dear, no, can't say that.
Huh?
You might have to mute somebody.
Mm.
And then to do that, we have Kevin Washburn and Matthew Fletcher. And just to introduce our speakers, so you know who is speaking to you, we have Kevin Washburn, and he is the Dean of the University of Iowa College of Law and a scholar of federal Indian law. In addition to being a professor, he served as the Assistant Secretary for Indian Affairs at the U.S. Department of the Interior during the second term of President Obama. And he also led the transition team for the Department of the Interior when the Biden-Harris administration took office. As an academic, Washburn's research has focused on indigenous conservation, including tribal co-management of federal lands and land back for tribal nations. He's the co-editor-in-chief of Cohen's Handbook of Federal Indian Law, which is due to be published soon, and a citizen of the Chickasaw Nation of Oklahoma, and grew up mostly on or near the Chickasaw Reservation in Oklahoma. Matthew Fletcher is the Harry Burns Hutchins Collegiate Professor of Law and Professor of American Culture at the University of Michigan. He sits as the Chief Justice of the Grand Traverse Band of Ottawa and Chippewa Indians, the Pokagon Band of Potawatomi Indians, and the Poarch Band of Creek Indians. He's a member of the Grand Traverse Band and graduated from the University of Michigan Law School. So we're thrilled to have both of them here with us. I don't know if we ever decided the order. You guys can
You
maybe
don't get to decide.
Okay, good. You do. You can virtually arm wrestle. And yeah, we're really
the
thrilled to
dean has
have you.
decided I go first. So here's the book
All right.
that you referenced. It's very large. This is what Kevin Washburn does in his spare time.
Well, and if we're going to do that, here's one of Matthew's books, one of his many books, but this is one that's kind of in a similar vein,
Wow.
we both have each other's books on the shelves. He's got a lot more books than I do. So
That was
he's a bit different guy.
fantastic. We've never had that happen, I don't think. That was great. Well, you guys, yeah, take it away. We're just thrilled you joining us, and it could spare some time for our group. We're thrilled to learn more. And as journalists, as you can see, we've got quite a distinguished duo here to teach us about these things.
Yeah, so I'm going to start with a little bit of an Indian Law 101, and I'm going to tell you all the bad news about how the Indians lost their land, and Kevin's going to tell you the good news. And then whatever happens after that happens. So, okay, I don't know how much I heard you have heard from other people who know a lot about this stuff, but I'm going to give you the Indian Law 101, which in my view is actually pretty simple. I'm going to talk about a few principles of Indian law that are foundational, go all the way back to the beginning of the United States, and if not before, and how that's a good and a bad thing. So first thing you need to know is Indian law is federal. That's why it's called federal Indian law. Indians and Indian tribes are the only race or ethnicity mentioned in the text of the United States Constitution. So whenever anybody tells you that some aspect of an Indian Affairs statute or Indian preference or something is unconstitutional, what they're saying effectively is that the text of the Constitution is unconstitutional. So because Indian Affairs is mentioned in the text of the Constitution, Congress has sort of the leading role in Indian Affairs as a general matter. We have a notion in Indian affairs federal Indian law that we refer to as plenary power. The United States government has plenary power in lots of different areas of law. They have Congress has plenary power to deal with commerce. Congress and the executive branch, the president, have plenary power to deal with foreign relations. They have a treaty power. President has the power to declare war, intends to take lead in military activities, although Congress has a role certainly to play in that. Indian affairs are all sort of in the same mix. At the founding of the Constitution, Indian tribes are considered foreign nations for all practical purposes, although just somehow different because foreign nations tend not to be included within the territorial boundaries of the United States. So very quickly on in the first 13 colonies, there were a bunch of Indian tribes located within the boundaries of the original 13. And there always have been Indian tribes located within the territorial boundaries. So we have both a level of foreign affairs type um, power vis-a-vis the United States government, and also by virtue of the treaty power. And you've heard of Indian treaties, of course. And we're also domestic in that Congress has the power to pass domestic regular old laws vis-a-vis Indian affairs. So that's the first key principle you need to know. The second, generally speaking, is that states have no say in Indian affairs. There is actually a Supreme Court case saying state law has no force in Indian country. And if a state law conflicts with a federal statute in Indian affairs, the Supremacy Clause of the Constitution kicks that state law right out. And that principle of state law having no force in Indian country is something that has been very much ignored or riddled with holes over the course of the history of the United States, but that's the baseline rule you start with. The third key principle is that Indian tribes are sovereign entities, and they're mentioned in the text of the Constitution right next to foreign nations and state governments, both of which are acknowledged as Indian tribe or as sovereign entities. So in the original position, tribes start out as foreign nations with all the powers of a nation that any nation possesses, subject to what we call the duty of protection or the trust responsibility. The tribes enter in agreements, often with treaties or statutes or some other contractual arrangement with the United States government. It sort of sets out the rights and responsibilities of each side and how relations are going to go forward. Tribes often give up many aspects of their sovereignty, most notably foreign affairs type aspects of sovereignty that other nations possess. Tribes have generally given that up, although I'm going to tell you there's some tribes out there who don't think they have given that up. So we'll set that aside for a moment. So the other key principles of federal Indian law, the key principles really started out in what we call the Marshall Trilogy, the first three big Indian law cases out of the U.S. Supreme Court: Johnson v. McIntosh, Cherokee Nation versus Georgia, and Worcester versus Georgia. The latter two are sort of the same case. Now, Johnson versus McIntosh is really important for us today because that sets up the entire property rights regime of the United States. So, as you well know, when the colonizer came to what is now the United States of America, there were indigenous people living here. And the colonizer's law treats indigenous peoples as subhumans for all practical purposes. They gave it a name, Doctrine of Discovery. The Doctrine of Discovery is that the colonizing nations that came in had the right of God behind them. Indigenous peoples do not have God, therefore they are easily submissive to the colonizing nations from Europe. The Doctrine of Discovery basically holds that indigenous peoples do not have the power as subhumans to own property in the same way that sovereign nations from Europe, and with the benefit of God behind them, and the colonizers that they sent out to colonize us and to engage in foreign relations with us here in indigenous peoples, they kind of sputtering here. So step back. The Doctrine of Discovery says that Indian people are subhumans who don't have the same property rights. Effectively, what that meant was that the only governments or people or whomever that Indian tribes could sell land to were the discovering nations, the colonizing nations. So originally that was first, depending on which part of the United States you were in. If you were in Florida, that was Spain. If you were in the East Coast, that was mostly southeastern coast, that was mostly England. If you're in the Northeast, it was often France or a combination of England. If you're in the Great Lakes, like I'm from, it's mostly France originally. And whoever was the sort of the primary colonizing nation was the, quote, discoverer, and they were the entity that claimed, quote, sovereign title over the area. And it was only that government that Indian tribes could sell their land to. They were the only ones they could deal with for all practical purposes. So early on, if tribes sold land to some rando individual, British, French, Spanish, English, American, that land sale would be void, could not be enforceable in court. You could only sell, if you were a tribal nation, your land to the discovering nation, the colonizer. And so that's how we start. And most of the east coast of the U.S., the eastern part, east of the Mississippi, was divested from tribal nations through the process of land cessions, usually through treaties, where tribal nations would sell land at pennies on the dollar in the fair market to the colonizing nation, usually in the United States, although on the East Coast it was often other nations at first. So that sort of principle and tradition extended out to the west of the U.S., all the way up to California for the most part. The United States would purchase land from tribal nations and then set aside Indian reservations. West in the Mississippi, a lot of those reservations are pretty large. We're talking the Great Sioux Nation Reservation. The original version of it was basically both Dakotas, parts of Montana and Wyoming and Nebraska, even into Canada somehow. I've seen maps. Those reservations will be parceled out, eventually chopped up with additional treaties or land cession agreements, or just straight up confiscations. The Black Hills in Wyoming and South Dakota is a really good example of the federal government just confiscating large chunks of an Indian reservation for its own purposes, and then declaring post hoc that this confiscation wasn't really a confiscation. It was a retooling of a tribal asset from cash into little or nothing in terms of just compensation. And eventually you have smaller and smaller Indian reservations out west throughout most of the latter half of the 19th century into the 20th century. And starting in the 1880s, the U.S. embarked on a plan to chop up these reservations. That was a plan known as allotment, where every reservation, which was a large block of land or groups of chunks of land, parcels of land owned collectively by tribal nations as one owner, chopped up into individual parcels through an allotment plan of 80, 40, 160 acres, what have you. Each head of household of a tribal or an Indian family would get an allotment, and that allotment would be held in trust for 25 years. And at the end of the 25 years, the land would effectively go out of reservation status and become a fee allotment. Fee just means a regular old piece of land. And at the expiration of this trust period of 25 years, a lot of Indian people would have to start paying Indian taxes on the land, just like other American citizens, and they would lose their land, or they would lose their land through fraud or coercion or just straight out violence. Or if they went on vacation and came back and the land was gone, somebody would say you've abandoned your land. And from the 1880s until the late 1920s, Indian land holdings went from about 140 million acres to 40 million acres, something like that. And all of that was through the allotment process. And so basically that gets us to the 1930s, and Congress passed a law in 1934 that did a whole bunch of things, but one of the key things, and Kevin will talk about this, is the power of the Secretary of the Interior to acquire land and trust for individual Indians and also for tribal nations. This is a key element in the current land back movement that often goes underappreciated. But that's there. It's been sitting around since 1934, and it's totally unfunded. So the tribes have to buy their own land back and then give it to the Secretary of the Interior, our lovely colonizer and trustee, in order to restore that land to reservation status effectively. But throughout most of the 20th century, tribal land patterns remained sort of static. But the tribes lost a lot of the land through the allotment process. Individual Indians lost a lot of their land, and that remained basically the same throughout the 80s and into the 80s and 90s. And I'll stop there. There's a lot more to say, but I don't want to use up too much more time so that Kevin could talk about the modern incarnation of land back vis-a-vis the federal government or whatever he's going to talk about.
All right. Thank you, Matthew. Kevin, the floor is yours, and then we'll have some Q&A with our journalists.
You guys just got about 8 or 10 weeks of federal Indian law thrown at you in like 10 minutes, and that would have cost you, several $1,000s at the University of Michigan. So you should be very thankful. Matthew gave you the quick summary. I'm going to give you I'm going to slow it down a little bit, and I'm going to do a slideshow. And let me just say this. Matthew's the brains of the outfit here, and I welcome him interrupting me at any moment to challenge me or to add on or whatever. But so what I've been trying to, people have been talking about land back the last 4 or 5 years, quite a bit. And we actually do a lot of land back in the federal government. I mean, we do it. It's not a new idea. We've been doing it for years. And I just don't want that to get lost in the discussion, because no, we're not going to, we're probably not going to see all of North America returned to indigenous nations, but here and there we're doing it. And I think it's the right thing to do. But I've been given this talk. I've kind of worked up this paper that's going to come out in UCLA Law Review. And so I've been kind of trying to explain it to people, kind of the federal role in land back. And so I'm going to go there. And let me just say, I welcome any of you to interrupt me as I'm going along. I don't mind that at all. So it's a great idea, and it's not a new idea. Matthew talked about the Great Sioux Nation, and you may know that the Sioux tribes won a case in the U.S. Supreme Court, got a judgment for $100 million for the taking of the Black Hills, the wrongful taking of the Black Hills, and yet they have said, we don't want the money back. We want the land. We want our land back, and so they've not accepted that money. It's now worth more than $2 billion or something like that in the federal treasury. And I mean, people are serious about this. This symbol is really powerful. I love the imagery. And this is that's up on the screen now. This is the logo for the Indian Collective. And the Indian Collective has been given gifts of $175 million in various grants since 2018 to work on restorative justice issues. But one of the central ones is land back. And it's really incredible. I mean, there's really significant interest in this from funders. Here is one of their protests from back in 2020. They've demanded the return of the Black Hills, among other things. And I think Nick Tilson, who runs the Indian Collective, I think he spent some jail time after this protest. I think this was when Trump went out to Mount Rushmore, and I think Nick Tilson got arrested. But he's one of the leaders of the Indian Collective, and hero trying to make all this stuff happen. There's been some, kind of several different claims. David Troyer, who's a literature professor actually at USC in LA, and also a novelist, he wrote a book called The Heartbeat of Wounded Knee, which is nonfiction recently, but he argued that all the national parks should be returned to tribes. That was pretty bold, kind of claim. And because they're the most iconic public lands, that was an interesting and provocative claim. That was in the Atlantic Monthly in 2021. There's a University of Chicago law professor, Todd Henderson, who proposed a slightly different arrangement. He said that the federal government should divest itself of all of its land holdings except military bases and the national parks, and transfer ownership all the other lands to native tribes. Also wrote that in 2021. That was in Newsweek. It's been out there. I always like to mention a word about language. I use the word Indians, and I want to apologize for that in advance. It's a dumb name for this whole area. It's a mistake made by Christopher Columbus. He was lost, and so we got this name Indians. It's stuck, and so we still use it, but it's on the Indian Gaming Regulatory Act and the Indian Child Welfare Act and numerous other laws, the Indian Civil Rights Act, and so we still use this word, even though some people, it's clearly not the right word, and B, some people I think are kind of starting to find it offensive. And if you hear me say Indians, that's just because I've spent a lot of time in New Mexico, and that's the way Pueblo is pronounced, Indian. So, at any rate, I ask for your forgiveness in advance for that. So one of the questions is why land back, and I probably don't need to explain to you why it's a good idea or why it's right. It's around, there's a lot of different ideas. Reparations is one of them. And I would say it's not full even if we gave all of North America back, returned to tribes, it wouldn't be full reparations because a lot else has happened besides just the taking of lands. And I use this image instead of an image at Wounded Knee, which, you know, showing soldiers shoveling native bodies into a trench. I mean, you know, the vision from Wounded Knee is just as bad as the visions from Nazi Germany in 1945. It's the same. It's hundreds of people dead on the ground, women and children included, being put into a mass grave. And so there's the reparations go way beyond mere land. Another motivation is sort of social justice. Social movements are playing a big role here, and also indigenous environmentalism, and that's the Dakota Access Pipeline kind of influence. You know, tribes are not into the extractive industries, most of them at any rate, and so environmental justice, indigenous conservation is part of it too. There's been a lot of support for indigenous conservation. A couple of years ago, a bunch of groups, some of these groups included on the screen, got together and pledged $100 million to support indigenous conservation. And that used to seem like a lot of money. It doesn't so much anymore because the numbers have gotten so big. But a last reason why is indigenous knowledge. You know, there's all kinds of utilitarian arguments that tribes are just better at managing lands and conservation than others are. And I'll give you one example that I think kind of underscores the importance of indigenous knowledge. And there's a famous anthropologist, Franz Boas, who famously speculated in the early 1900s that the Inuit people have 50 or perhaps even 100 words for snow, the word snow. You know, they've got millions of different ways of describing snow. And it was quite a controversy, actually. People didn't believe it at the time, but that there could be 50 or 100 words for the same thing in an indigenous language. But a meta-review more recently of dozens of linguistic studies on more than 100 distinct terms used to define sea ice kind of came out with the same way. There was more than 100 terms to define sea ice by indigenous people in Alaska and Canada. And if there's that many fine distinctions in the way to describe snow or sea ice, that's science, that's wisdom, that's knowledge. And I think that's one of the best examples that, you know, there's a lot of knowledge out there that indigenous knowledge has access to that wouldn't be, considered the same as science, ordinary American type science, or, you know, what we do in universities, but is definitely science. It has all the knowledge and features of science. So a lot of different reasons for land back and respecting tribes in this area, and getting tribes returning land and getting tribes involved in co-management. I like to posit that land back is sort of probably the most significant of a bunch of different kind of initiatives that are all sort of justice related and restorative to tribes, but it's just one in a bunch of others. And so I'm going to just run through these really quickly. One of them is renaming. And anybody recognize this? Anybody? I want to unmute and say what this is.
McKinley.
Well, I got the name on
Denali, of course.
I didn't do a good job. Yeah. So Denali,
Isn't that a truck?
What's that? Yeah,
It's a truck.
That's right.
An SUV.
That's right. It's a GMC pickup. That's right. Masquerading as a mountain. That's funny. This is the tallest peak in North America, and it was called Mount McKinley until President Obama changed it back to Denali, and that was a wonderful day. I got to go to Alaska with him when he announced that. It was an Arctic Council event up in Alaska, and that was obviously very well received by natives, and I have to say, renaming something to some degree it's related to land back because it's reclaiming things. And it's land back adjacent, I think, because once you've recognized that that's not Mount McKinley, that's Denali, you're recognizing some tribal ownership in that, right? That you're recognizing the tribal interest in that mountain. Another thing is national monuments, proclaiming national monuments and protecting them. And so this is the ancestral footprints of the Grand Canyon National Monument that President Biden proclaimed. I think it's around 900 and some thousand acres in these 3 different parcels around the Grand Canyon. And tribes have an arrangement to help guide the management of those lands. I won't call it full co-management because it's less than that, to be quite honest. Tribes aren't controlling those lands, but they've got an important voice in it. And that is not unrelated to land back, I think. Bears Ears is another one. You're going to see, you guys are all going to be reporting on Bears Ears soon, I fear, because, the Obama administration created the Bears Ears National Monument. And then Trump reduced it, arguably unlawfully, reduced it from 1 million acres to 200,000 acres or something like that. And he actually took the Bears Ears out of the Bears Ears National Monument. It's named for these iconic features that from a distance in profile look like the head of a bear and bear's ears. He famously removed the Bears Ears, Trump did, from the National Monument. And then Biden got elected and restored it. And so we'll see, it may be an early action of the Trump administration to undo that again. But declaring national monuments and creating roles for tribes in the management of them is, adjacent to land back. This is a national monument that's very near where I live. This is outside Dubuque, Iowa, on the Mississippi River, the Effigy Mounds National Monument. And these are effigies. These mounds are effigies of animals that were created by tribes, indigenous people, ancient indigenous people, who are long gone from there. But this national monument has a sister park arrangement. It's run by the National Park Service, and they've got a sister park arrangement with the Iowa tribe of Kansas and Nebraska. And so they share employees back and forth and stuff. And so that's another kind of way that parks are working with tribes to work together. National Parks is working with tribes. And so that seems adjacent somewhat. This is the Grand Portage National Monument up in the Arrowhead of Minnesota, that little point way out in the far east side, north of Lake Superior of Minnesota. And the Grand Portage Band of Ojibwe Indians gave the land to the National Park Service for this national monument. And they have a 638 contract or a self-governance compact to help run the monument. And so they get some of the funding that National Park Service would have spent running this monument. And so they are truly managing it. This is a true co-management arrangement because the National Park Service is actually paying the Grand Portage Band to help manage this monument. And that seems like somewhat adjacent to land back too. There's all kinds of other examples of sort of co-management, including the various fish commissions and wildlife commissions that tribes do. There's also these other things that are kind of adjacent to land back. And one of them is restoring criminal justice, criminal jurisdiction to the federal government and tribes in partnership rather than to being run by states. And this happened during the last Trump administration. Is the Meskwaki tribes criminal jurisdiction was retroceded from the state back to the tribe and the federal government. And this is hopeful, right? Because this was a bill sponsored by Senators Grassley and Ernst, two Republicans, and the local member of Congress that was also Republican. The whole delegation here in Iowa is Republican. And Trump signed this bill, and it was actually, restoring power to the Meskwaki tribe in Iowa. So, as a practical matter, here's another example. This is the Yakama Nation in Washington State, and that's Governor Jay Inslee, the white guy in that picture in the jacket. Here this is an example of retrocession that the executive branch, the Obama administration, did. Restoring criminal justice authority to the Yakama Nation. But this kind of stuff is happening. And arguably, I showed you a congressional example and then an executive example. And arguably, the McGirt case is a judicial example of retrocession. I mean, recognizing the reservations in Oklahoma as a practical matter restores criminal jurisdiction to tribes in Oklahoma, and including my own tribe, by the way. And so this retrocession, restoring tribal criminal jurisdiction, is significant, and it's adjacent to land back. My own tribe, by the way, went from hearing 75 cases a year, criminal cases a year, misdemeanor type cases, to hearing 50 cases a week. sort of right after McGirt was decided. That was the result of McGirt. Suddenly, we've got very active criminal docket at my own reservation. Here's another example of that I think is it's not land back per se, but it's the restoration of reservations. So the Shakopee tribe in the Twin Cities area has been buying back its land. There on the right is land that it has been reacquiring. The green land, the light green land, is in trust, and the yellow land is land that they've bought that they will probably put in trust. But when they do that, they can put it in. They bought it, as Matthew mentioned. You know, the tribes have to buy their own land back, but then they can get it put in trust, and they can actually get the assistant secretary or the secretary to declare a reservation, that declare that land is a reservation. And the Shakopee tribe has been building back their reservation, 100 acres here, 12 acres there, 200 acres there, and they've been gradually rebuilding a reservation by buying their own land back. And by the way, I'm not talking up the Trump administration, but they did it too. Some of these were taken. These declarations were made during the Trump administration. So they've worked with the Obama administration, they worked with the Trump administration, they worked with the Biden administration to reclaim their land, and it's happened under under all of those administrations. So that's that's a range of restorative initiatives that are close. Now I'm going to turn to land back, and I'm going to apologize for talking so long. And let me pause there and ask anybody that wants to add anything, or Matthew, any reflections on any of that? I welcome it.
No, I've just been trying to annotate you in the chat.
Oh, good. Uh-oh. I can't see that right now. So, but that's good. That's good.
Oh, in a good way.
Truth checking in real time. Is
Even
that
the
right?
pro-Trump stuff.
Well, it's I'm trying to be hopeful. I'm trying to say,
know,
I mean,
right?
my message to everybody is we got to keep trying to get stuff done, even if there's a Republican in office. I didn't vote for him. I will tell you that. But we can't stop. We gotta be persistent still. All right. So now I'm going to talk about land back. What we do is that
Actually,
is
Kevin, we got a
actually
question if you want to talk about fee to trust, because the question from Lucy is who has the power to approve or disapprove if a tribal purchased land could be put into trust?
So that is it's a discretionary act by federal officials. The Assistant Secretary for Indian Affairs has the discretion to take it goes to the secretary under the law that Matthew mentioned, the Indian Reorganization Act of 1934. But it's been delegated to the Assistant Secretary, and the Assistant Secretary has further delegated to the BIA. And so the director of the BIA or regional directors of the BIA often do that. The gaming applications at times have had to go to Washington, but sometimes regional directors or even lower officials than that, superintendents of specific reservations, have been able to make trust decisions, land into trust decisions. So I think that's Matthew, want to add anything to that?
Nope, sounds right. I just sent a link to the 25 CFR part 151.
Okay, this is a smart group. This chat may be better than what I'm doing. I'm sorry, but at least I'm giving you something to riff off of. That's good.
This
So
is
let me
good,
go
yeah.
let me go into the land back and the different kinds of land back that we do. So okay, let me how to get back in this. Okay. So, and Matthew mentioned this is around the time of the signing of the Indian Reorganization Act. That's the Flathead tribe visiting with Harold Ickes as the guy sitting at the table signing something. You can see they weren't in practice yet. They hadn't figured out how you do this. Everybody's supposed to look at the camera and grin whenever the federal official is signing stuff. You see it now in presidential signing ceremonies all the time. These people gathered closely around the president, hunched up. And this one is they were still working out how to get this done, but that's Harold Ickes, Secretary of the Interior, and John Collier standing behind him, a former commissioner of the BIA. This, and you're gonna hate me, but here it goes again, talking about Republicans. One of the most iconic examples of land back is Blue Lake at Taos Pueblo. Richard Nixon took from the Forest Service and gave back 48,000 acres of land to the Taos Pueblo in 1970, and as it was an act of Congress, but he supported it. He asked for it. He got it through Congress, and he gave it back to the Taos Pueblo. And reportedly, he got front page above the fold positive coverage in the New York Times, which even though he won 2 elections, he didn't get a lot of positive coverage in the New York Times. And word is that after he saw those stories, he called over to the Department of the Interior and said, "What else you got? Well, send over some more of this stuff for me to sign, because this is this is pretty good press." But that's one example of Republican land back, and I'm just saying, I'm not, I like when Democrats are in charge, but we got to keep asking Republicans to do this stuff too. Here's another example: the National Bison Range at the Flathead Reservation. It's right in the middle of the Flathead Reservation, this land, it was kind of a stick in the eye to the Confederated Salish Kootenai tribes, because right in the middle of their reservation, fully within the exterior boundaries of the reservation, was this acreage of around 18,000 acres that was run by the Fish and Wildlife Service. That was the National Bison Range. And the tribe first tried to contract to run it, and that worked out okay, but it went sideways when some of the neighbors and even some of the employees of the Bison Range sued over it, and that kind of had to stop after federal court litigation. And the Obama administration started having conversations about just returning the National Bison Range to the Flathead tribes, the Confederated Salish and Kootenai, and it didn't actually pass Congress until Trump was in office, but Trump signed it. And there were some Republicans that were supportive of that too, because one of the senators and the representative, I believe, from Montana at the time were both Republicans. And so there's an example of Trump, another example, Meskwaki, and this one, of Trump signing bills that were involving sort of, positive outcomes for tribes and restoration of power to tribes. Now, here's the issue, and this is, Matthew kind of alluded to this when he talked about how much of the Western United States was ceded by treaties. This is a map of ceded lands that are ceded in treaties, specifically in treaties in the United States. You can see it's about 80% of the, the mainland U.S. So it's a lot of land, and it's a clear example that this is tribal land. Yeah, is this a public map? I borrowed this map from a friend, and I've been having a difficult time finding the actual records, but it's an interactive U.S. Forest Service map is what it is. And there is a version of this, I think, that has all of the 718 different sessions that are listed that justify this map. But I've had trouble finding it again, so apologies, or I would put it in the link. But I think it's directionally true for sure, and I was surprised at how much of this is in the the Midwest and the East and the South even, these various treaties. Here's the issue. Here's why federal lands are a good target for land back. All that purple land in the slide on the left, that's federal land. That's all land that used to be tribal land. All the little postage stamps on the right are the land that tribes now own, and some of those are, or I shouldn't say own, that are now considered Indian country, or tribal lands. So in Oklahoma, for example, this is post McGirt. Most of Indian country most of Oklahoma is considered Indian country. It's Indian reservation. Tribes don't own all the land within Indian country, of course, just like a county doesn't own all the land within a county. But these are lands where the tribes at least have jurisdiction over them, and often own, a lot of the lands within them. So returning land to tribes is difficult. This is, though, it shows who the target ought to be. It ought to be the federal government. When you're talking about land back, the federal government owns a lot of the land, and that's where you should go. if you want land back. And you can see it's funny putting these two pieces together. It would be purple, quite a bit more purple if you put these two together, because you can see in the Four Corners region that there's a gray spot on the federal lands map. There's a purple spot on the tribal lands map. That's the Navajo Nation, of course. Down south, there's the Tohono O'odham Nation, and for example, and then you see the two Apache tribes also kind of cut out of the federal lands in Arizona. And you see the same thing. There's the Wind River right here in Wyoming, and there's the Wind River over there on the tribal lands, Wind River Reservation. So it's kind of interesting. It's like putting a puzzle together. But tribes, ought to be looking to the federal government, and because that's where the land is. It's like, why did Willie Horton rob the bank? Because that's where the money is. The federal government is where the land is, and so that's why tribes should be looking to the federal government for land back. And BLM is the biggest U.S. landholder. Forest Service comes in second. It's over the Agriculture Department. BLM is part of Interior, but then Fish and Wildlife, National Parks, and Department of Defense comes in, much smaller than the rest of those, but the total's around 640 million acres. So there's a lot of land there to try to get back. And here's all the federal land color coded. This is a USGS map, color coded by which agency has control. And there's a lot of agencies, obviously. And there's some that I didn't mention, like the Bureau of Reclamation and such, and the Army Corps of Engineers and such, that also have significant control over some of these lands, especially in Alaska. But again, it's the right place to go to look for land. And by the way, it solves a lot of problems if you go after the federal government, because the United States is the same guy that took the land in the first place, wrongfully, right? If it comes to your home or my home, well, there's been a bunch of people between us and the people that originally took the land wrongfully, right? There's been a lot of bona fide purchasers for value, and it wouldn't be, it's much more disruptive, where it's a lot less disruptive to take the land from the federal government, which is the same owner that stole it in the first place, in essence. So that land in a trust process that Matthew talked about starting in 1934 and that I've talked about, here's some example. I mean, we've been using it. The Obama administration, we worked really hard to get lots of land into trust, and we got more than 500,000 acres of land into trust during the Obama administration. And the Trump administration, though, took 75,000 acres into trust, according to their records. And so they were still doing it. They weren't doing it as fast a pace, but they were still doing it. And the Biden administration, I heard this figure as of November 2023, because a federal official said it, but then I've had a hard time documenting it. So take that with it. We don't know what the number is. They may have reported it on Tuesday or Monday at the Tribal Nations Conference, but I didn't see it yet, so I'm anxious to figure that out. But they've taken a lot into trust as well. Another way to get land into trust in the federal government is through the base realignment and closure process. I don't know if you all know about this, because it's old, but there was a statute called the Base Realignment and Closure Act, which provided, it's controversial to close military bases. But once the Soviet Union sort of went away in 1980, and we thought the Cold War was over and the world was going to be a very peaceful place, we started shuttering military bases around the country. And there was a process, because no member of Congress wanted the base in their district to be closed. They created this BRAC process, the Base Realignment and Closure process. And but one of the things about the BRAC process is, in conjunction with the Department of the Interior, tribes can say, we want that land back. There's a possibility they've got high priority for, when you close a military base, getting land back. And it's a really hard process. And frankly, it's dirty land. It often has unexploded munitions and ordnance on it. And so it's got to be cleaned up, or you got to figure out who's liable for all that before the tribe takes it back. But there was more than 1,000 acres of the Badger munitions plant that went back to Ho-Chunk after it took a few years and took some heavy action by one of their U.S. senators. And then there's Fort Wingate, which is about 20,000 acres near Gallup, New Mexico. And That one was designated to return to tribes, but it was the Navajo Nation and the Zuni Pueblo, and it was like I think it was around 20,000 acres. And the challenge was that Zuni and Navajo couldn't agree to how to just split up the land that was returned. And you can imagine they both thought that they deserved most of it. And ultimately, at the end of the day, after several years, 25 years or something of arguing about it, it was split evenly and returned half to Zuni and half to Navajo. So it took a long time to get there. There's also, but there's a bunch of other examples too. There's land in San Bernardino that was part of the Norton Air Force Base when it was closed, and the San Manuel Band of Mission Indians got that land, got a chunk of it. It was only like 20 or 40 acres or something like that, not a huge amount of land, but not nothing. Here, and here's a picture that they turned it into a logistics center. It's a very kind of industrial space, but they've you know, they're using it for economic development. Obviously, that water tower was the iconic thing about Norton Air Force Base. So they left the water tower up, but it's but that's now tribal lands. Here's another possibility for land back. This is the Otis. I think it's called the Otis Air Base is what it was called, but it's on Cape Cod, and the Mashpee tribe really would like to have that land back because it's been questions about how badly we need a air base on Cape Cod, and so there's been talk about getting this base you know, shuttered and returned. So a bunch of other examples. Here's a recent private example. The Penobscot Nation worked with the Trust for Public Land, which transferred 30,000 acres of land back to Penobscot near the Katahdin Woods and Waters National Monument. And this was private. This is not federal. This was private, but it was a, you know, a conservation organization, the Trust for Public Land, that decided to return the land to Penobscot, I was delighted because that's a chunk of land. And here's another quick example. Governor Walz. This was before any of us knew that he was going to be, you know, on the ticket. But in February of 24, February this year, the Minnesota DNR. I mean, this is Biden was still running. Tim Walz was not on anybody's radar screen outside of Minnesota at that point, but he gave back the Upper Sioux Agency State Park to the Upper Sioux community, and it's 1,200 acres. It was a state park. Now, why would the state own a park named after the BIA agency that controlled Upper Sioux community? I don't know, but so it seems like it was the right thing to do to return that. But that's a good example of you know, another example of a state returning land to tribe. I think there needs to be a lot more land back. Here's one of the places I think we really ought to focus. And this is these lakes along the Missouri River. They're called lakes, but they're dammed up rivers is what they are. And as many of you know, during the reclamation era, the water reclamation era, when we're building all these dams, it was often Indian reservations that got flooded to create the dams. And so, you know, the worst impact of these dams was always on Indian reservations. And these are some examples, Lake Sakakawea and Oahe. And I would like to see a land around those reservoirs returned to tribes. A lot of the statutes said that the land must be returned to tribes. And once the land that was not needed for the reservoir, and the Army Corps and the others that own that land have tended not to return the excess land. And so it's time for that to happen. So that's the presentation. I'll stop there, and I haven't been following up the chat because I couldn't talk and do that. I'm not. I can't chew gum and talk at the same time.
Me either. I don't know how people do it, but that was great.
But I'll stop there, and we can make this more of a conversation. And I hope it was helpful to just see the different kinds of ways that the federal government, you know, even today and even in Republican administrations sometimes works to return land to tribes.
Yeah, thanks, Kevin. Appreciate it. So, folks, I've totally lost the thread if you were trying to ask a question in that chain. So we're going to start afresh and have you post in the chat if you have a question, and we'll go from there. So whoever wants to go first, let me know. Okay, Ashley, first out of the gate.
Thank you. And thank you, Matthew and Kevin, so much for all the knowledge. I wanted to follow up on your Trump administration example. So you talked about some actions and some undoing. So I'm curious if you have recommendations of what to specifically look for as far as land back and restorative policies going into the new or the second Trump administrations. Just as far as like what journalists should be looking for.
Well, so I would say that to the extent that positive things happen, it's going to happen mostly in places where you've got a Republican congressional delegation that's asking for it, right? I mean, they're not going to be doing favors to Democrats generally, probably. And so that's when the tribes are aligned with Republican congressional delegations, that's the right alignment for, for this kind of thing to happen. The National Bison Range is an interesting example because it really was the Fish and Wildlife Service that decided during the Obama administration that they decided they were willing to give that land up and went to Congress. And I suspect that people didn't want Obama to get credit for it, so they just delayed it for a while. But there was no real Republican objection to it. So once Trump was elected, it was allowed to happen. There may be things like that lying around. I don't know. There may be more of that. So we could, in the early Trump administration, see things that have been lying around in Congress that, that as long as the Democrats not going to get credit for it, they'll let it go through. So we'll see. I don't think there's a whole lot of those things, but there may be, there may be some, and that would be finding out about that would be talking to members of the Natural Resources Committee on the House side, and that's probably the primary place to go to figure that out.
I would add something that Kevin probably wouldn't say, or maybe even agree with, but in my experience as a lawyer during a Republican administration, which was primarily Bush W, the Republican Party was very much a pay to play. If you wanted land under trust, you had to provide lots and lots of money to the Republican candidates, Republican sitting members of the congressional delegation. My tribe got some land in a near Traverse City, Michigan, that we knew kind of was going to be really hard to put into trust for purposes of gaming. So we decided not to do that. But the initial discussion we had with a law firm out of DC that handled that sort of thing for another tribe called the Seneca Nation. They said, look, it's going to cost you $1 million, $2 million, maybe $3 million. And here's a list of all the Republican Party members that you need to donate to. Do it through our firm. And what it does is it reinforces the firm primarily, number one, and reinforces certainly the Republican coffers. And that's how it's done in Republican administration. And I don't know if Trump is the same way, but I mean, I think my senses of his presidencies are that he's a pay-to-pay guy. If you have money to give to him or whoever his allies are, then you can get stuff done. The tribes that benefit under Trump that benefited were the ones that have oil and gas exploration and mining interests. They benefited greatly under Trump, and they will continue to do so in this next administration, to be sure. If you're a tribe like one in Michigan that's like trying to stop pipelines, you may as well just close up shop for the next 4 years. Or however long Trump's going to be in office, 30 years.
Thank you both very much.
Lucy, you're next.
Thank you so much for that, both of you. That was absolutely incredible to listen to. I'm going to apologize in advance if I've misinterpreted one of the maps, but what really caught my eye was how much of Oklahoma is tribal land. And I was wondering if there's ever been any studies done to compare the health of the land, the health of society, the health of people who live in Oklahoma to other areas in the US that have returned very little land to Native Americans.
So Lucy, that map has only been that way since 2020.
Okay, so it's very recent.
Yeah, it was the US v. McGirt case. I'm sorry, the McGirt v. Oklahoma case that held. This is the case. Justice Gorsuch famously wrote this line, at the end of the Trail of Tears was a promise. That was his opening line, which, powerful line. And he basically said, and, went on to say in the opinion, we're going to hold the government to that promise that this land is Indian land. And, but for a century, we had treated that land as not Indian land. And so it's really only been restored to tribal, this understanding that that those are Indian reservations, since 2020.
Okay, thanks
And-
for clarifying.
And Lucy, our first session tomorrow will be looking at some of the results of the McGirt decision from some of the tribes in Oklahoma.
Oh, great, thank
So,
you.
Okay.
I just
Sarah.
add, I put a link
Oh, go
into
ahead.
I put a link in for a paper by a colleague of mine, Jeff Zahn, who used to work for the Federal Reserve or the World Bank or something money oriented, who studied the economic indicators pre and post McGirt. And I don't know, the end's kind of small on this one, just a few years, but it says that it was a response to Oklahoma's claim that the entire economy of Oklahoma would collapse as a consequence of the McGirt decision, which was patently false. So there are also studies out there about tribal gaming per capita payments for the tribes pre and post game per capita. And I would take a look at some of those. They are Eastern Band Cherokee, I know, has been studied repeatedly. The outcomes are actually pretty good. I'm the kind of guy who's like, don't give the money away. We need that for like healthcare and housing. But the reality is that a minimum income actually is very beneficial to tribal communities.
It's true, and it doesn't take very much money either. Those some of those are, $4,000 or $5,000 a year. It makes a dramatic difference in poor people's lives.
All right, thank you. Sarah.
Hi, I live in a state, Missouri, that doesn't have any federally recognized tribes, and I'm just curious what your thoughts are on land back in a state like that. There's plenty of federal land, as we saw on your map, Kevin, so what are your thoughts about that, and what would it take to have movement in that direction in some of those states like Arkansas, Missouri, Illinois, that don't have any kind of federal tribe recognition right now?
Well, there have been some efforts, and there is a tribe that I believe just repurchased land in Illinois, and I believe got it taken into trust. And so tribes are starting to, be active. There's been a tribe that's long been trying to get land into trust in Arkansas, for example, the state south of you. And so it's starting to happen. It's a long road, and I think, as Matthew said, there's lots of money that needs to be spread around for it to happen. I think that, it's often kind of depends on the participation of local officials going along with it, oftentimes. And so, making friends one way or the other with local officials is probably key. I don't know, Matthew may have more to add about this.
I mean, it's like anything, you look for the angles, and if there are angles, you'll figure it out. I mean, Trump signed a statute recognizing 6 Virginia tribes that tried for decades to get federally acknowledged, and all they had to do was give up their gaming rights.
From what I hear from someone from Mattapani, which just filed for its recognition, that wasn't a big deal with them, because she says, oh, they're all Baptists, they don't gamble anyways. But who knows if that's just anecdotal or if that's factual, or are their kids going to want to do gaming and curse their folks for signing it away? Who knows? We'll have to wait and see.
I can kind of follow up on that, actually, because I was just on their reservation a week ago. And right after they did applied for their federal recognition. And I think I was next on the list, Adam. So
you
So,
beat me to the punch. So there you go.
So Virginia is very interesting, and I don't understand, as a Commonwealth, if this has any sort of other federal or state implications in the way land back law is handled in Virginia. And because I've talked to a couple of the different nations here about it and sort of what they're going through. And they're dealing a lot with the state, and some of the treaties in Virginia precede our Constitution. they're still active. And so I was wondering if you guys might have an idea of lawyers or scholars who specifically know the implications in Virginia. These are some of the, some of the, the Powhatan Nation is one of the oldest nations. So I'm very interested in trying to understand sort of the mechanisms that the tribes are having to work through, whether it's going federally recognized. Like you said, we have 7, 2 more just in the last month have applied. Still a few others that don't, but do have state recognition. So I'm interested to hear what you have to say about that, or if you might have some leads I could follow up with.
So generally, there are really 2 primary ways for a tribe to get federal recognition. And one is to go through this very clunky process at the U.S. Department of the Interior before the OFA, the Office of Federal Acknowledgement.
Right.
And it takes a long time, and it takes a long time for a variety of reasons. But one of the reasons is that they do genealogy on every single person that's named in the application. And honestly, the tribe pretty much has to submit that stuff. So often the tribe needs gaming backing to, develop the expertise, to hire the PhDs that you need to do that work. And so often it's a gaming company that's helping fund the tribe's recognition process, but it nevertheless takes decades. And there's a lot of other requirements too. That's just one of the very expensive requirements. That then is done, the review is done by a set of PhDs at a genealogist, an anthropologist, and a historian, I believe, are the 3 types of PhDs that look over that review. And once they're done, a separate set of PhDs peer reviews the first set's work. And so it's a high hurdle to get through there's 6 recognition criteria. They have to have been a government basically since time immemorial. And when I was assistant secretary, I tried to reform that to make it a little bit easier for tribes, and made at the margins made improvements. But to be quite honest, there was a hell of a lot of pushback politically, including from senators in Connecticut that don't want to see a bunch of groups that have already been defeated by the state in Connecticut sort of, get to be recognized. That's the long process, but where that office gets its legitimacy is because of the rigorousness of their work. It needs to be rigorous because they're not Congress. They have, they've got to show that people have to believe that this is science, that this tribe should be recognized. Congress can do it with this, one fell swoop. They can just sign a document. If they can get passed, it doesn't need to have any backing behind it. It doesn't even have to be true. It's if Congress says a tribe is a tribe, then it's a tribe. So that process, in some ways, it's politically harder. It's substantively much easier. And so those 6 tribes that were recognized in Virginia were recognized shortly after I was the assistant secretary that recognized the Pamunkey tribe. And Pamunkey was Pocahontas's tribe. And they had, in 400 or, they'd been around forever, but they had good evidence going back 400 years of their existence, but they had always had a relationship with the Commonwealth of Virginia since long before the United States existed. And so they hadn't perceived that they needed federal recognition. But they decided to seek federal recognition, and it was the best application that that office of the Department of Interior had ever seen, and I got to be the one to sign it. But it took a few years, but it was politically we faced some significant opposition in recognizing them, including from the majority leader of the United States Senate, Harry Reid, at the time, who threatened me. For doing it and told me not to do it. And so it's even when it's done by that office, by the Department of Interior, it's nevertheless some politics kind of comes to play in it. So the congressional path is a better path in some respects because it's a lot quicker and doesn't require the hoops. One of the big issues recently has been around the Lumbee tribe, and because they're in North Carolina, which is a battleground state. Both the Trump campaign and the Harris campaign were sort of courting the Lumbee tribe something like 100,000 Native Americans that would like to have, they've got some federal recognition, but they're barred from any federal services, and they would like an adjustment to their status to true federal recognition. And it, you know, it's a big political battleground, but ultimately Congress needs to act to make the Lumbee tribe, to get them recognized. Follow up?
Okay. Did you just ask for a follow-up, Chris?
So if he wants it, I'm not sure I
Sure.
answered
Well,
Chris's
yeah,
question.
yeah. Well, you know, there's definitely some significant issues in Virginia, specifically going back because of the Racial Integrity Act in the 1920s that really made it very difficult. And probably all the tribes that got federally recognized through Congress probably would not have had that chance, honestly, if it didn't go through Congress, because they wouldn't be able to chase their ancestries back. But I'm interested, you know, with those particular tribes, how does the land back at the federal level work? And is there, because I'm hearing that it has to go to the state first, not federal.
No. Well, it doesn't have to go to the state first for the federal, for it to go to the tribe. And there's actually one of the tribes in Virginia there's an agreement around it's like the Chalk Cliffs or something like that. Does that ring a bell? There's it's on a river. I am sorry, it's just I haven't thought about this in a long time. But there is a tribe that has gotten some at least land back or a co-management agreement with like a state park or a federal, I can't remember if it's a state or a federal facility. I think it might be a state facility now that I think about it. But there is some action. I mean, you know, we have parks everywhere, and we've got more federal parks out west, but we've got some federal parks and national monuments throughout the east too. And if there are still tribes in those areas, I think there's knocking on the door is important. You know, the Biden administration is coming to an end, and the Park Service has been Chuck Sams, you know, a Native American, has been running the Park Service, and we've had Deb Haaland at the helm at the Secretary of the Interior. And so my argument has been go knocking at the door, because those Park Service regional directors are really wanting to do this because they will please their bosses if they do them. And so it's been a good time the last 4 years to go get these agreements, and there's been dozens and dozens and perhaps hundreds of new agreements signed between tribes and national parks. But it may be that the strategy needs to change towards state governments, you know, in blue states now for tribes. And I think that's a good strategy, because they still may have the interest in doing that sort of thing. Sorry, I'm talking too much, but.
No,
Thank
that's
you.
fine.
Thank you.
That's what we asked you to come here and do, Kevin. So you're doing great. Maria has a question.
Hi, I'm reporting on the presence of state trust lands on reservation land, so state-owned land within reservation boundaries. And one of the things that I've come up against is when I'm talking about this issue with folks where tribes are trying to get that land back to reservation status, confusion about why, when the land goes back to the tribe, it must be held in trust by the government to be a part of the reservation. So I'm wondering if you have any recommendations on how you'd explain why it has to be that way, where the federal government holds the land in trust, but tribal nations manage it, whether there's any benefit of the federal government holding in trust for it to be considered protected reservation land. And then also, if there are any questions that you think aren't being asked of this policy, why it has to be this way and whether there are consequences of it.
It's a lot.
I'm gonna
That's
ask
good.
Matthew to
Yeah,
weigh in here, but let me
sure.
say your work, you and Anna's work has been amazing. It's awesome work. So thank you for the good work you guys are doing on this issue, because I hadn't thought about it too much until you guys started writing about it. But Matthew, let Matthew go first, and then I'll speak up too.
Well, I'll say generally that tribes have been attempting to reacquire their lands within their historic reservation boundaries. So when a tribe does that, it owns the land in fee. And so there's a big dispute as to whether or not they have to continue to pay property taxes or taxes for the activities that occur on that land, or whether they're regulated in terms of zoning and land use ordinances by the local governments. And the one solution was followed by the Oneida Indian Nation of New York in upstate New York, where they would just say, declare this is Indian land, and it's part of our prior reservation, and it's never been terminated. So when we reacquire it, it becomes reservation land. The Supreme Court rejected that theory in a case called City of Sherrill versus Oneida Indian Nation in 2005. Said if you want your land to have the immunities, tax and regulatory immunities, you have to go through the fee to trust process. And that's what Oneida did. So the advantages of land held in trust on behalf of Indians and tribes by the United States government is that it's owned by whatever the advantages are of federally owned lands. So it cannot be taxed, and activities on that land generally cannot be regulated by virtue of the fact that federal law is supreme over state law. And so when tribes acquire this land in trust, they don't have to deal with the state and local governments for the most part. It also Indian tribes need the land to qualify for certain federal benefits. You know, you have, if you're going to put up a federal public or tribal public housing with federal money, it has to be on trust land. If you wanted to open a gaming operation, it has to be on trust land. And a lot of the things that tribes do, that vis-a-vis federal programming, have to be on trust land. Housing and gaming are the two that just pop in my head. I'm sure there are others. And so that's the reason. And there are absolutely consequences. We were talking about this in the chat earlier. You know, individual Indians who live on trust land cannot collateralize that trust land. So they're kind of stuck if they want to borrow money for purposes of putting up a house or collateralizing any of their property interests. They're in trouble. They have to rely on, you know, maybe a tribal program or the Bureau of Indian Affairs loan guarantees. And those are difficult, to say the least. So that's why we still put land in a trust, but sometimes we choose not to. I mentioned my tribe in Michigan. We bought this big giant resort property called the Grand Traverse Resort. We're happy to keep it out of trust. We pay our taxes. We make local governments happy. We keep a big giant property from going into bankruptcy, and you know it's been created a lot of business and political goodwill for us in the region. And if we took it into trust, that would create problems for us, frankly. So we just don't do it.
Yeah, and I'll just add, I mean, underscore what Matthew said. I mean, the issue here is, do you want your property protected by federal law or state law? You know, and tribes want their property protected by federal law. Those are the only two options, by the way. Our country doesn't recognize, you know, sort of tribal ownership as being immune from state taxation, only federal ownership. And there's an old, you know, kind of famous case called McCulloch v. Maryland that says states can't tax the federal government. And that's the concept, is that it's the superior sovereignty of the federal government over states means that states can't tax anything the federal government owns. The power to tax is the power to destroy, that case famously says. And so we can't allow states to be able to tax federal property. And so by getting the federal government to take land into trust, we've now federally protected it from states. But our Constitution, sadly, only recognizes really specifically two types of sovereigns. I mean, in this way. And you know, the tribes weren't invited to Philadelphia in 1789 to be part of this compact known as the U.S. Constitution, and so their interests weren't protected. And they're mentioned, but they're mentioned as something other. And so that's the basic principle: is we only have two models, a federal model and a state model, and tribes would be generally, except for what Matthew said about, you know, sometimes they're okay paying state taxes because it buys some goodwill, but generally you'd rather be free of state taxation and state authority. And when you get your land taken into trust, it largely frees you from any state authority over that land. And that's what tribes want. It's a power game.
Thank you both.
Yeah, thanks. All right, Serena.
Thank you both for so much information. I feel like I'm kind of swimming in it right now and it's prompting a lot of questions. So this might be kind of a two-part question. I'm still thinking about, yeah, state versus federal kind of challenges and opportunities. Earlier in one of the sessions, we talked about California going through its own truth and reconciliation process right now, and Washington possibly doing the same. And I imagine there might be some land back proposals out of that. So apologies if you've already kind of answered this, but what powers do the states have to give state land or state park land back that maybe does usurp some of the federal laws or challenges? If you could break that down a little bit better. So what you said a minute ago, Kevin, about maybe we
Yeah.
should look at state
Yeah.
parks
Yeah,
and
yeah,
the state.
yeah. Yeah, there's no, I mean, that's a matter of probably the law of in particular states and whether there's the political will to pass a law to change the law, basically, here's the problem with public officials. I mean, it's good in a way, but public officials have a fiduciary responsibility to look out for their constituents. And giving away your constituents' assets is not something you generally want to do, right? I mean, that's the issue. And so you need to overcome that in progressive states by saying it's wrong that we have this land. We need to give it back. And so that's basically the principle. There's no federal obstacle to states returning land to tribes. But yeah, so I guess that's what I would say about that. Matthew may want to add something.
No, not a whole lot.
California has been very progressive on these issues, more so, 10 times more so than any other state. And I'm moving there. I'm joining the faculty at UC Berkeley in August. I'm very excited about that because I got a lot to learn about California California. There's a lot of the most interesting stuff in the country is going on in California. Also around recognition, by the way, California recognizes a lot of tribes that the federal government does not. And so the distinction is really breaking down in California between recognized and non-recognized tribes.
Maybe, Kevin, you could help persuade the Indian Arts and Crafts Board that because California recognizes us, it means we're covered under IACA, because right now they're saying we're not.
Well,
I'm doing an article about it.
Yeah, or get California to pass the same law. I mean,
Yeah, we're just recognized, right? And we're acknowledged for cultural reasons, as you know. Anyways.
Right.
Okay, Hector has a question.
Yeah, thank you, Kevin and Matthew, so much for being here and sharing all this information. One thing I was really curious about, I'm here in Missouri also at San Sarah, where we don't have any federally recognized tribes. And one thing that I've been really interested in lately is the Osage Nation recently, through a land transfer, now has ownership of one of their mounds near St. Louis, Sugarloaf Mound.
Yeah.
They've been working for years to try to get it back. I think there's one more property owner who owns it, but they almost have the majority of the land back. And so I'm very curious, like, what are your thoughts on, the Osage historically being from here, no longer being here because, of course, forced removal, but working towards, regaining some of this land that is not that is here in Missouri instead of where they currently are.
I love that idea. I mean, let me say that one of the great examples is in Indiana. Indiana is Indian with an A on the end, and there's no tribes there, or there were no tribes there until just recently. And one of the Michigan tribes, was it Pokagon, Matthew, that
Pokagon.
purchased land in South Bend where Notre Dame is, and they've built a casino. And I mean, they've done doing economic development there, but they're reclaiming their lands in other states. And let me underscore something that we didn't make really clear. It's great when tribes are actually in new state, go back to states that they aren't currently in, because those states have 2 senators and multiple members of Congress. And so if a tribe is active in a state, that means they've got access to those members of Congress. And as Matthew said, it's a corrupt regime in the United States. You got to pay to play, but having a lobbyist and and constituents can open a lot of doors in Congress, even among red states and red delegations. So so it's good. And Hector, I had not heard about Osage. Osage, I think, I think they're the ones that have been trying to acquire land in Arkansas, or have acquired land. And the question is, can they get it in trust too? So they're they're doing a lot.
It does happen occasionally. I know Oklahoma Wyandotte got some land in trust in Kansas City, Kansas. It was really controversial. It was a cemetery. They put a casino on it, so forget the optics, but they were able to do it, and I think it's viable. But you have to remember the tribes that maybe Missouri is kind of easy, but if you go back to some of the tribes that have been forced out of Michigan, if they start coming back, I guarantee you the Michigan tribes are gonna stand at the border and block all their trucks and everything. There was a tribe, the Ottawa tribe of Oklahoma, tried to bring a lawsuit and some lobbying in near Cleveland, where they're originally from Ohio. In fact, the famous Chief Pontiac was an Ohio Ottawa chief, Ogama, and so they're from there, and they came back, and Ohio was obviously went nuts and did everything they could to destroy the effort. And the Michigan tribes are really terrified because they were trying to make an argument that we were here all along and always had this right. And the response to that is the city of Sherrill case, which the other part of that case is terrifying, which says if a tribe or a group of Indians brings a claim that is disruptive to the settled expectations of locals, it can just be summarily dismissed. And some of those have been. Some of the upstate New York land claims have been summarily dismissed. And it's like this weird get out of jail free card for state and local governments to use anytime they feel it. It doesn't usually work, but you just never know.
Okay, thank you guys. I think Anna has a question.
Yeah, Kevin, Matthew, nice to see you both. Thanks so much for talking with us today. My question is kind of a fishing expedition just because I don't know that much about it, but I'm curious about both of your thoughts in terms of how tribal law could interact around conversations of land back and all of the more specific ways, but also kind of like those broader ways that we were talking about earlier. For example, I know that like the Yurok extended rights of personhood to the Klamath River, that's limited to their jurisdiction area. But I was just curious if you both have any thoughts about tribal law and specific instances there that kind of coincide with these conversations.
This is Matthew's department, so I'm going to stand back.
Yeah, I would look to Stacy Leeds wrote a paper 20 years ago, 25 years ago, suggesting that tribes take land into trust themselves under tribal law. And I'm going to put a link in there, and I think that a gentleman named Bill Rice, who's walked on, probably wrote some of that stuff too. That link is terrible. It's to Hein Online, so I'll give you the MLA link or the citation anyway. And that's a possibility. I mean, tribes have sovereign immunity, kind of like the federal government does, at least vis-a-vis the states. So there's some argument that tribes are able to avoid state immunity or avoid state taxes and local regulation by virtue of their status as sovereign entities. But it's definitely no slam dunk. And all it takes is 5 votes on the Supreme Court to just say, well, hey, tribes are immune from suit for most things, but not from state and local taxation. I mean, there's nothing to stop the court from doing that, except you just need 5 votes. So it's no guarantee, but that's definitely a use of tribal law. I would also add that tribes, and I'm just going to bring some stuff up that I didn't really have a chance to earlier. In Michigan, we've done some things that I guess you could constitute that would constitute land back. The big one is where we persuaded the United States and the state of Michigan to allow off-reservation hunting and fishing rights on state and federal public lands. So, we don't own those lands, but we have regulatory authority over our own citizens who engage in hunting and fishing activities on those lands. So we've got some cases that show tribes exercising civil and criminal jurisdiction off the reservation, which is kind of surprising to some people. So I just sent you a link there to what are the state and federal public lands. Most of those north of, well, basically you see the Isabel Indian Reservation in the middle, but everything up there, all in green and blue is, green is stuff where the tribes exercise jurisdiction. I would also point out, the tribes in Michigan, 10 of the 12 have tax agreements with the state of Michigan where for purposes of taxes, we totally renegotiated our reservation boundaries. We don't really have reservation boundaries in Michigan. So the link I sent you has a tax map in it. And you'll see the link will show that in Grand Traverse Bay that we have what we call an agreement area legally, but it's much broader than our actual reservation that we negotiated for in 1836 and then again in 1855. And it's more representative of where our citizens actually live. And, these are just sort of interesting ways that tribes can, reclaim aspects of their own territory, older territories. And Yeah, so I just want to put that out there.
Matthew,
This
what
is just to
taxes?
add.
What taxes are implicated? Is it property taxes and sales taxes and gasoline? I mean, do you have a sense of what taxes
Yeah,
tribal people don't have to pay within that tax agreement area?
it's the state taxes. So property
Oh.
taxes are not included because they're local, but income tax, if I live and work within the agreement area, I do not pay state income tax. I have to file, but I don't pay. Motor fuels, tobacco taxes. There used to be these business taxes that were repealed but later by a later administration. Those are the big ones, and sales and use taxes. So yeah.
Good.
If you're doing activities and you live within the agreement area, which is basically broader than the reservation, you pretty broad tax immunities.
Okay, so I think we did it. We have one final question, and it's not on this list. It's because it's from Francisco. And there's never time to ask.
Yes,
But you
I
have
know.
it.
I always have
You
questions, but I always defer to everyone. But actually, Serena had a question. You could go ahead.
I'm happy to defer to you if you want. Yeah, mine's
Well,
kind
it's kind
a
of
law
it's kind of
policy
related.
question. Okay.
It's kind of related because it's kind of more of a broader question.
Why don't you
And it
reframe mine how you like?
Well, your question has to do with like legislative frameworks, and I'm kind of curious on your take on other countries' treaties, and I'm specifically like the Treaty of Waitangi in New Zealand, and I'm kind of curious on your take on that as a document for like a legal framework between tribes and colonizer nations.
I get the sense that the United States is the only government that recognizes the sovereignty of indigenous tribal nations in the world. Canada sure doesn't, and I'm guessing New Zealand and Australia do not either. Maybe it's an accident of history, but the fact that the U.S. acknowledges tribes as sovereigns in the Commerce Clause of the Constitution and they have a history of entering into treaties. You don't enter into treaties with states or corporations or local governments or the Boy Scouts or anything like that. Only Indian tribes and foreign nations. So that's a huge thing. And even, the sovereignty of indigenous peoples is not even in the United Nations Declaration on the Rights of Indigenous Peoples. That was something that's too controversial to be included. So that's a huge strength for tribes. That said, there are enormous problems for tribes that they have to overcome, which is primarily the United States Supreme Court and the Department of Justice. I mean, federal sovereignty and sovereign immunity and sovereign prerogatives absolutely hold sway in the federal judiciary. So does state sovereignty to a large extent, even in federal Indian law. And those are principles that are sort of unwritten rules that go all the way back to like Alexander Hamilton, the Federalist Papers. They're not even, many of these things are not even in the text of the Constitution. So that's the kind of fight we have. That said, even there are things that are bipartisan legislative initiatives that tend to go really, really well for tribal nations, and most notably the expansion of tribal criminal jurisdiction and cooperation between federal and state law enforcement authorities. The cynic in me says, one thing governments can all agree on is that Indians got to go to jail. So they're all in on that. And Indian country crime is a serious problem, and it's an easy political win for anybody who wants to back some sort of initiative. And over the last 2 decades, things have happened in Indian law that I think Kevin and I are both shocked by. Probably one is McGirt, but the other one is like the slow erosion of this Oliphant versus Suquamish case that stripped tribes of the power to prosecute non-Indians for crimes. Congress is crime by crime restoring that to tribal nations, at least the tribal nations that have the resources to actually prosecute non-Indians and follow, the kind of onerous financial and legal obligations that come with that. They can opt into this. And so those are if you find those angles, even in a Republican administration, you're going to find places where tribes can benefit.
All right, thanks. And last, just because it is a good question from Serena, is there anything that should be on our group's radar in terms of like pending legislation or court cases that might be, impactful in this arena?
I would say I mean, we're in wait and see mode for for Congress and the executive branch right now. And so there's not a lot of legislative stuff, I think. But in the courts, you know, there's stuff going on all over the country, and it's hard to know which ones will be big. But all the stuff is in Oklahoma can cause changes, and in good ways and bad, I guess I would say. There's a lot of litigation spawned by the McGirt case, and some of it could go sideways for us. We'll see. But Matthew.
Okay.
Yeah, I mean, I think there's probably more crimes that tribes are going to be able to prosecute non-Indians for in the horizon, and more resources available to tribes, and obligations of the federal government in particular to cooperate with tribes and law enforcement. So that's the one thing you can fully expect Congress to be pretty supportive of, is more cops in Indian country. And whoever the cops are. But that's, I don't know. There's no real court cases going on. I mean, here's the thing about the judiciary in Indian law. If you're a tribe, it's not like you can just bring a case to make change. We're always playing defense. We never want these cases to go to the Supreme Court. I mean, that's the worst case scenario. Every time we go there is an existential threat. All it takes is 5 votes to gut. You know, that book I showed you, Kevin's book, I mean, a third of that could go away in any Supreme Court case. So, I mean, that's the last thing we want, is these cases to actually to go anywhere.
Colleagues, I got friends waiting outside that want to meet
Yeah,
with me, but
we
thank
gotta
you
go.
so much for having me
Here's your
here.
round
This
of
is great.
applause. Thank
this
you
is
guys
an
so
amazing
much.
session. Thank you both so much.
And journalists, you did it. You made it to the end of day 1. We will see you back on this Zoom channel tomorrow, 11 a.m. Eastern, 8 a.m. Pacific. Kevin and Matthew, thank you so much. That was exactly what we were hoping it would be. So that was super informative.
All right, good deal.
Appreciate it.